Good morning, everyone. Good morning, good morning, good morning. It's Josh Goldstein, your favorite immigration lawyer, coming at you. And today we are talking about delayed visas. More specifically, we're talking about the solution to a delayed visa, which, as you know, if you followed my content, is a writ of mandamus lawsuit. Now, what is a writ of mandamus lawsuit? A writ of mandamus lawsuit is when you challenge the processing delay. You stand up and you say, damn it, this isn't fair. This isn't right. This isn't normal. I deserve a decision on my immigration case, and I deserve that decision within a reasonable period of time. You're not doing your job, and that's why I'm suing you. That's what a writ of mandamus lawsuit is. And what you hope to get out of this lawsuit is a decision, a final decision. Now, why would you have to file a lawsuit in federal court just to get a decision on your immigration case? That's a good question. And the answer is that the immigration agencies are not doing their jobs, and that's why you have to take action. And the question that has come to me, and this is the topic that we're going to be talking about today, is when is it possible to file such a lawsuit? Well, I have thoughts on that, and I want to share them with you today. And if you don't know me, I'd like to introduce myself again. My name is Josh Goldstein, and I'm an immigration lawyer, and I am based in Los Angeles. I also have an office in Boston. So we're on the East Coast and the West Coast. We help people in all 50 states and around the world. And we're really dedicated to helping you reach your immigration goal, whether it's getting a work permit or a visa or a student visa or a green card or whatever it is. We want to help you get there. We want to give you practical advice. I've been practicing immigration law for more than 20 years, and I've made every mistake there is to make. And I can share this information with you so you won't make the mistake that I made. I'll just make it on your behalf, and that way you can learn from everything that I've done. I also want to inspire you that you can really do this. You can reach your immigration goal. An amazing life in the U.S. is possible for you. And you and everyone watching this can do this. I see we're getting a lot of questions from YouTube and TikTok and Instagram and LinkedIn and all these other places. It's so great. I'm so grateful that everyone take the time to join me and to spend time here. And if you have a minute, I'd love to hear from you, and I'd like to know more about where you're from. I'm here in downtown Los Angeles. Let me know where you are. Put them in the comments below. So I want to get back to the topic at hand, which is, when is it possible to file a writ of mandamus lawsuit? When can you do it? And the answer is, it depends. Now, I hate that answer. It depends. Sometimes we used to have judges that would come and they would say, well, it depends, and it's on a case-by-case basis. And I always thought that was kind of a bullshitty answer. It was kind of a cop-out, and it is. But let me tell you a little more about why I think that. So the basis of a writ of mandamus lawsuit is that there's been an unreasonable delay. Okay? The delay in your immigration case has been unreasonable. And the question is, how long is long enough that you would have to file such a case? When does a delay become unreasonable? When is that? And the answer is that it depends, and it's on a case-by-case basis, which I just said was kind of nonsense, but nevertheless, let me give you a little more thoughts on this. When the last action was taken by the government, how long has it been sitting there? How long have they not been doing their jobs? The first thing we want to look at is the amount of time that's passed since the government was supposed to do its job. How long has that been? Has it been, did you go to your interview a week ago, or was it 2 years ago? We need to know. And the second thing we want to know is, what else is going on in your life what else is going on in your life that makes the delay incredibly difficult for you? I always ask clients 3 questions. First, I ask them, if I could wave a magic wand and get your immigration case approved right away, how would that change your life? How would that change your life? How would it make your life better? What problems in your life would it solve? And that's one thing I really want to do. Um, the second thing that I do is I ask clients, if you don't reach your immigration goal, how would that impact you? What would it mean to you if you're not able to reach your immigration goal and 6 or 8 months from now you're in the same spot you're in now? How would that impact your life? And the third thing I ask them is, how important is it to you to reach this goal? Those are the 3 things that I ask. So in each case, if you come to me and you say, Josh, I'm tired of waiting, I want to file a mandamus lawsuit, the very first thing I'm going to do is ask you questions about what's going on in your life and how long and when did you file your case and how long was it? I ask all these questions because I'm trying to figure out whether the delay in your case has been unreasonable. Does this make sense? Let me know in the comments below what you think about that. And in the meantime, let me take a few questions that I have that people have sent me over the last week that I think are pretty good questions that may be helpful to you. They're about this and other topics. And then if you have other questions, post them in the comments and I'll get to them as soon as I possibly can. So hang on a minute. Okay. This question comes from Sissy Namasi from Sissy Namasi is from Kenya. No, Uganda. She says, I'm in Uganda. My son won the green card lottery in 2020. He went through the process. I'm at Nairobi. And at the Nairobi embassy, he did the biometrics 2 times. He left his passport with all his original documents. But since that time, he got nothing. Only in July, they sent him a message, and he went to see that message and didn't get anything else. He didn't even get his passport back, and we're confused. We missed a lot of chances. He could not travel because of his passport. Okay, so it is now 2023. If you won the green card lottery in 2020 and you did not get a green card yet, then it's too late. The way it works for the green card lottery, the DV lottery, is that anyone who is selected to get a green card through the DV lottery must complete the immigration process by September 30th of the fiscal year. September 30th. So if October 1st rolls around and you don't get the green card through the DV lottery, you lose. You're done. You're out. These cases are incredibly, incredibly urgent. Okay. So if you don't get the green card by October 1st, you're done. So if you say your son won the green card lottery in 2020 and it's 3 years later and you want to know where your green card is, it's over. You're not going to get it. Just because you're selected for the green card lottery does not mean you're going to actually get the green card. Getting the green card requires effort and luck. And, that's why people hire immigration lawyers to advocate for them. I would say, I'm sorry. Now, as far as getting your passport back, you can contact the consulate or simply apply for a new passport. But I don't think you're not going to get the green card. Let me go back and answer some more questions. Let's see here. Now on YouTube, we have Shirish, who says, my H-1B is under 221G, and it's been exactly over 6 months now. What would be the appropriate time to file the mandamus? And I mean, how many months can we file mandamus for? I would say if you've waited 6 months, that would be a reasonable amount of time to wait when you could file a mandamus lawsuit. I would want to know also more information about your case. I'd want to know, like, are you at risk of losing your job? Do you have an apartment in the US? Like, what's going on? And Shares furthermore says, I want to avoid getting the case dismissed and get a positive result. Would the case get dismissed if we file soon after 6 months? Should we wait 8 months to get a positive result? I mean, here's the thing. The longer you wait, the stronger your mandamus case is going to be. But the longer you wait, the longer you wait. So the question is, how long is long enough? There's no clear answer on that. I don't think you should wait too much longer than 8 months. But I think you should try. I think you should go for it and consider it. And if you go to my website at www.jgoldlaw.com, you can find a link in my bio. You can book a free strategy session with our team, and we will give you advice on whether we think that your case is appropriate to file a writ of mandamus lawsuit. So let me know. I'll take some more questions. If you have questions, put them in there. What is the wait time we have on TikTok? We have that's the name of this person on TikTok. What's the wait time for DACA renewal? I would say about 6 or 8 months. Probably. That's about as fast as things are going to happen in immigration. All right, I'm going to take another question. This is someone contacted me about a week ago. Maricela Ahmed Al-Assi. Hello, me and my husband have been married for 7 years, and I'm a U.S. citizen. He is from Egypt. We went to our interview on April 12th, 2023 in Cairo. Our lawyers sent them all the documents, but the embassy is not satisfied with all our documents we sent. We haven't heard from them in several months. What do you think we should do? Well, it's a very common story, and I'm sorry you're having to wait so long. If you go to your visa interview and you don't have a sufficient number of documents, then what happens is they send you a request to provide additional documents. And it sounds like that's what happened. And you responded, you did provide documents. The problem is you haven't gotten a final decision on your case. And what this means is that they're sitting on your case. They're sitting there and they're making you wait and wait and wait. And there's one thing that you know if you follow my content, and that is I believe that waiting leads to more waiting. There are very few immigration cases that are resolved just by sitting there and waiting. You have to take action. You have to take action to get anywhere. So it's been April, May, June, July, August, September, October, November, almost December. Life is passing you by, and I think you should consider a mandamus lawsuit. File a lawsuit in federal court, sue the government, and force them to make a decision on your case. That's what I think you should do. You should consider doing at this point. What other questions do you have? I'm going to take more questions from you. Let's check out and see what questions we have on Instagram. Love the gram. Love it. Let's see here. More questions. Jose Carlos Valdez says, can a TN visa turn into a green card? Not directly. A TN visa is a special type of work visa for Mexicans and Canadians through NAFTA. It does not directly result in a green card. It's just a temporary work visa. But if you have a TN visa, you should begin to explore other options. A green card through marriage, through a petition. There are lots of ideas. Okay. On YouTube, we have a question here from Janelle. Says here, my husband petitioned and approved for his ex-wife over 30 years ago, but FOIA requests show no record found. Can we put an estimated filing date on the current I-130 for the previous filing? I think so. Yeah. That sounds reasonable. We have Lua Habil. How much is a mandamus lawsuit? The price that we charge is based on a lot of factors, and if you're interested in filing a mandamus lawsuit, then you should book a free strategy session with our team, and we'll evaluate your case and see if it's a good fit for our practice. And if it is, we'll give you a fee estimate. But it's hard. We don't have a set fee. We just look at each case individually. Um, Here we have on LinkedIn a question from Khalud Dawahi. I hope I didn't butcher your name. Hey, Joshua, I have a friend that you may be able to help. I hope so. His mom's case is pending since 2016. After attending the interview, they denied her case without clear justification. In September, when he asked why is it denied, USCIS said the embassy denied it and to reach out to the embassy instead. The embassy told them they're terminating the case, and then after the events in Gaza, they told her if she's willing to evacuate to Egypt, they will grant her an interview. Very political and heated. Huh. That's interesting. I don't quite understand that. If they denied her case, why would they offer her an interview? She should book an appointment with our team. I've been thinking a lot about the situation in the Middle East and the people in Gaza, and I would love to find a way to help people. So that would be great. Here is Michael Coral, a friend of ours on YouTube. He says, hello, my cousin has been separated from his family for 10 years for the whole asylum process. That's horrible. After he waited for I-45 process for 6 months, should he file mandamus? His family is being driven crazy. I would like to know more about this situation. So mandamus is about an unreasonable delay. And if you've been waiting 6 months for an I-45, I don't think you can go off and file a mandamus lawsuit. That's not going to work. But if he's been separated from his family, I wonder whether they filed an I-730. I'd like to know more about that situation. Yeah, I'd like to know more about what's going on and why it's being what steps has he taken all the right steps to reunite with his family? That's what I want to know. All right, another friend of ours, Mohammed Siddiqui. Hey Josh, my wife went to her interview in Mumbai for an I-130 and was handed a 221G. That happened in March this year. After we submitted all the evidence, we got a letter saying the F2A has retrogressed, and indeed it has. So let me talk a little more. Thank you, Mohammed, for your question. Let me talk a little more about this situation. So in order to get a visa approved, you have to have a priority date that is current, and there has to be a visa available. And that means that you have to look at the visa bulletin. And each month, the visa bulletin is published. And each month, it shows whether your particular category is current for your particular priority date. And you have to check this, and you have to understand how it works. And it's not straightforward. It's a little bit complicated. Okay? So what happened is this person was current. Mohammed's wife was current. And then she became not current when it retrogressed. Mohammed, there's nothing you can do except you're going to have to wait. Also, if it's possible for you to naturalize, you should consider doing that. Because if you were to naturalize, Mohammed, I'm assuming, is a permanent resident. Because that's what the F2A category is. But if you were to naturalize and you became a naturalized U.S. citizen, then you wouldn't have to deal with the visa bulletin at all. So there's that. Let's see. Annie Taher. It's been more than 3.5 years since my immigrant case was filed by my husband, and it's been almost 2 months, and I'm in administrative processing. I was given an approval letter first upon hearing the officer handed me 221G. I'm very sorry to hear, Annie, I'm very sorry to hear about the delay in this case. That's very frustrating, and I think that you should. Annie says, I have an approval letter as well. What do you recommend? Do you recommend I file a WOM, writ of mandamus, considering the approval letter and it's been more than 4 years I've been separated from my husband? Man, that is very, very heartbreaking. And I'm really sorry, Annie. I can't imagine how hard it must be to be separated from your husband for so long. I think it's frustrating when they give you an approval letter and then they tell you you have to wait. Like, what is that all about, right? But an approval letter doesn't have any legal significance. You have to be approved. You have to have the visa in your hand. And my thinking there is that you should book a free strategy session with our team so we can gather a little more information about your case to see if mandamus would be a good solution for you. I think it probably would be something to consider, but I'd need to know a little more about it before I can tell you whether I recommend it. Here we have Fernando. Hi, I'm in Ecuador. Priority date of January 22nd, approval in July of 2022. It says here, I had a consular interview on September 20th, 2023. 2 months and no response on 221G. Is mandamus an option, or should we keep waiting up to 6 months or more? Well, if it's only been 2 months, then I think it would probably be premature to file a mandamus lawsuit. If it's been 6 months, I think you should consider. That's when I think you're in the territory where it might be appropriate to file a mandamus lawsuit for a case like that. I also don't know what case type you have either. So that makes it a little hard. Is it a visa case? It looks like a immigrant visa, employment-based visa is my guess. I'm not really sure. But these are all the really, really good questions. Keep your questions coming. And also, if you don't know me and you're just tuning in and you're new here, Fernando is EB2NIW. Yeah, I would say 8 to 12 months would be when you're in the category where a mandamus lawsuit would be appropriate. I think if it's been 2 months or even 4 months or 6 months, that would be 6 months is closer to where I would start considering mandamus. Again, if you think about it from my perspective, anybody who hires me for a delay lawsuit, I want to see them get approved. I want them to get approved. I don't want them to be unsuccessful. Let me take another question that was sent to us. And here it is. This is from Nicole Adswode from Alberta, Albert Lea, Minnesota. She says, my citizenship was denied because of failure to prove good moral character. But how do I prove good moral character? I didn't know I was supposed to wait 5 years after the incident to apply. It will be 5 years and 4 months. Please, I need help. Okay, so let's talk about good moral character for citizenship. So one of the requirements to get approved for naturalization is that you have to prove that you are a person of good moral character. But you only have to prove that you've been a person of good moral character for a period of 5 years or 3 years, depending on how you're applying. So one thing that I would do if I were your lawyer and I was trying to help you become a U.S. citizen, I would look at your application for naturalization and I would look at your criminal history and I would ask if you have any criminal cases or any arrests or incidents, and I would find out when those happened. And if they happened recently, within a 5-year period, I might consider asking you to wait. And if you wait, you want to wait until the incident, the criminal incident, is outside the 5-year window before you apply. So, what you do is you look at today's date, you count back exactly 5 years, and then you ask when the most recent incident happened. And you have to make the calculation correct. Um, the most, the easiest way to cure a denial for good moral character under these grounds is to file a new application for naturalization and to file it later, so that the 5 years are outside the window of when you applied. I hope that helps. So Jackson on YouTube says, he has a good one. Good question here. He says, if dismissed, can we file again? If my mandamus lawsuit was dismissed, can we file again? That is a very simple question, but it requires a lot of information, and I would need a lot more facts before I could give you that advice. So I think if you're considering filing a new mandamus lawsuit, I'd want to know why the first one was dismissed. What happened? What were the grounds for the dismissal? And once I find that information, then I can give you advice on what happened and why to do it. Here's a question on Instagram. Please, I'm in Ghana. I want to come to the U.S. Is there any way for me to study there? Well, if you want to study in the U.S., you could apply for a student visa. You could explore that. Why not? Let me know what other questions you have. Let's see. What other questions do you have? Here we have Katrina. I'd love to leave my spouse. Please answer my questions. You do have a good question, Katrina. Filed a joint I-751. Can I file an abusive marriage while I'm waiting on my pending renewal? Katrina, if you're listening to this, I hope you are, because I can we can help you. If you get a green card, typically a green card through marriage is going to be a 2-year conditional green card. At the end of the 2-year period, you're required to apply together with your spouse, and you're required to show that the two of you have a marriage relationship that's ongoing. But what do you do if your relationship is not going well? And furthermore, imagine if your relationship is not healthy or it's abusive. What do you do in that situation? Well, there are provisions under the Violence Against Women Act for you to apply without your spouse. And you can also get a divorce and apply through that way. The bottom line is there are very good ways for us to help you. This is something where you really do need a lawyer to help you manage the process. And I hope you reach out to us, because this is a case that we are very, very good at helping you with. So, Katrina, thank you for your question. And I hope you physically abusive. Yeah, you need to get help, and we could help. We can help you with your immigration case for sure. Don't, I can help you with that. Yeah, that's a very, very good case for our firm. So we have a question on Instagram from Joe Cuteo Mwauma. How long does it take for USCIS to make a decision after USCIS received an RFE for a medical? Usually very quick. I would say within a month or two. So that's good. Suresh says, can we submit an inquiry through LegalNet for 221G status? Can we do it directly or only an attorney? Um, so I've devoted my entire career to helping people who are stuck in 221G. If you're stuck in 221G, I'm here to help. And I have given more thought to this issue than practically anyone I know. And I can tell you that you will not solve your 221G by submitting an inquiry through LegalNet. LegalNet is a tool that allows lawyers to ask questions of the State Department. And, um, if you submit a request, it would probably take you 6 months or more to get a response through LegalNet. And I assume that LegalNet would just confirm and say, we have inquired on your behalf with the State Department. And according to our inquiry, your case is under 221G administrative processing. So I don't think it's going to work. It's a good idea. People come up with all sorts of solutions on their own for 221G, like, hey, maybe I should file for a new visa or something like this. Lua Habil on LinkedIn says, is it possible to submit a lawsuit to get back the lawyer's expenses if the cases in Mandamus is won? And the answer is yes, but also no. Let me explain. So in every Mandamus lawsuit, we sue. And what we ask for is we ask the court to order the agency to make a decision within a reasonable period of time. We also ask them to grant an award of attorney fees. And the problem, though, is that to get attorney fees, you have to actually win the case outright. And if you win the case outright, you're very unlikely to win the case outright. And so it's very unlikely that you're actually going to get an award for attorney fees. And so you'll find if you were to look at my lawsuit, you'll see a request for attorney fees under the Equal Access to Justice Act, but you're not going to get them. Now, in my career, I have filed thousands of writ of mandamus lawsuits. And in only one case have I gotten attorney fees. So that gives you a little more information about how hard it is. So yes, you can do it, but no, you're not going to get attorney fees. Mr. Tusk on YouTube asked us a great question. I filed for removal of conditions based on cruelty for a year now. Is it okay to remarry my U.S. girlfriend while my case is pending? First of all, Mr. Tusk, I suspect that you do not have a lawyer, because if you filed based on cruelty, I think you probably did the case in a way that is not to your advantage. Let me explain what I mean. Katrina on TikTok asked about the I-751 removal earlier, and I want to explore that for a minute. So again, you get a 2-year conditional green card. At the end of the 2 years, to keep your green card, you have to file an application called an I-751. You have to apply together with your spouse. And these applications are pending for a long time. What do you do? What do you do if that marriage relationship is not going well, or it's abusive, or where there's cruelty going on? What do you do in that situation? And the answer typically is to get a divorce. And then to get a divorce, you can prove 2 things. 1, that you have a divorce, and 2, that your marriage was genuine when you entered into it. If you can prove those 2 things, you win. However, you can also do the case if you're not divorced based on abuse and cruelty. You still have to prove that the relationship was genuine. But let me ask you a question. If your marriage relationship involves cruelty or abuse, wouldn't you want to get a divorce from that person? I would think so, right? And secondly, you still have to prove that the marriage relationship was genuine. In my opinion, it's much easier to get a divorce, which you want to do anyway, and prove that you have a divorce by showing them the divorce decree, than to prove that your marriage relationship was abusive. Now, in those abuse cases, we still provide lots of information to USCIS about the nature of the abuse, what was happening in the relationship, and so on. I just think it's important to get a divorce. And furthermore, yes, Mr. Tusk says he used a lawyer, he's now divorced, and that was submitted as well. So if you're divorced, then the basis of your I-751 should not be cruelty. The basis should be divorce plus good faith marriage. That's my professional opinion. And is it okay to remarry? Yes. However, you can remarry. However, you can't get a green card based on the new marriage. You still have to, the basis of your green card. Oh, Katrina booked it. Thank you, Katrina. That's amazing. You still have to get your green card based on the prior marriage. Okay. Tusk has proof of domestic violence and lots of proof of marriage. That's good. That's really good. I think you're in good situation. Yes, it's free to you're free to remarry, but you can't get a green card based on that that marriage. What other questions do you have? I'm here for you. Ask me anything. Come at me. Ask me anything. Let me know. Let me know. Here's a question from Chivas Tapatia. I'm working on getting a letter of good moral character. Question: do they need to be notarized? If they do, people might not want to find a notary, especially in Mexico. They charge you an arm and a leg for anything from a notary. Please advise. So, good moral character is a concept that comes into play when you're applying to become a naturalized U.S. citizen. How do you prove good moral character? Well, you typically don't need to submit any affirmative evidence of good moral character. Typically, you establish good moral character by lack of criminal cases. So if you don't have any criminal cases, you probably don't need to submit additional proof of good moral character. And if you do need to submit proof of good moral character, a letter from a friend is not going to be given much weight. And so I think if you're trying to prove good moral character for naturalization, getting a bunch of letters from friends notarized is probably makes no sense. Benjamin Will said, I got a support letter from my recruiter. Can I use it for Mandamus? Worried I'm getting too old to serve. Expedite request has a government interest category. Mandamus, we have never submitted a letter of support, so I don't think you should worry about that. I'm glad that you want to serve in the Army. I think that's cool. And I hope you reach your goal. And if you do, we can help you out with that. Let's see.